Hello, my name is Hannah Adams. I'm a third year law student at Northeastern, and right now I have the honor of representing the program on human rights and the global economy in Geneva, Switzerland, at the UN's review of the United States' performance of its obligations under the International Convention on the Elimination of All Forms of Racial Discrimination, or ICERD. ICERD is a treaty that was adopted and opened for signature in 1965, and the U.S. signed on to it with reservations in 1994. And of course, it's a very important part of our international human rights canon. Because it ratified the treaty, the United States must periodically report to the Committee on the Elimination of Racial Discrimination, which oversees treaty enforcement. And then the committee writes what's called concluding observations about the United States' performance. Now, civil society organizations like CERD, as well as sovereign indigenous nations, have an opportunity to participate in the review by writing shadow reports on various issues where we believe the United States is not meeting its obligations. So I had the opportunity to work with Professor and Fergie co-director Martha Davis, as well as staff at the Columbia University Human Rights Institute, to research and write a shadow report on the issue of access to legal counsel in civil cases. This is a copy of the report. I know it's backwards on the screen. I'll link to it in this blog post. Obviously, access to civil counsel is a serious issue that we deal with in this country. As you know, Gideon versus Wainwright recognized that criminal defendants have a right to counsel, but there is no similar right recognized in civil cases, even cases where physical liberty is at risk. Studies show that people who do not have access to an attorney in cases where basic human needs are at stake, like eviction and foreclosure proceedings, child custody proceedings, public benefits, administrative appeals, deportation proceedings, face much worse outcomes than those who are represented, as you might imagine. For example, a recent study in Boston eviction courts showed that represented litigants fared twice as well in terms of retaining their homes and 5 times as well in terms of rent waived and monetary damages. And that's just one example of a recent study. The civil justice gap disparately impacts litigants of color because they are more likely to be involved in poverty-related legal proceedings, and they're also more likely to not be able to afford an attorney, and that's because of the way that poverty disproportionately impacts people of color in America. Though ICER does not specifically mention the right to counsel in civil cases, Article 6 of the Convention guarantees equality before tribunals. And also in 2008, at the last U.S. review, largely due to advocacy of Fergie and other civil society organizations, the CERD committee specifically commented on the disproportionate impact of the lack of right to counsel in civil cases on indigent persons belonging to racial, ethnic, and national minorities. And that was very significant. So our goal this year is that the committee once again provides specific guidance on the issue of access to counsel in civil cases. This language by an internationally respected UN body can then be used by advocates in the United States to push their issues through a human rights lens. Today, the U.S. Human Rights Network held an orientation for advocates who are attending the review that I went to. I will be working primarily with a group of housing advocates while I'm here, arguing that the access to counsel is a critical part of the human right to housing, which, of course, we are encouraging the United States to recognize. So now I'm going to go because I have not slept in a very long time, but I hope that you'll tune in tomorrow for an update from day 2 of my Geneva adventures.